D.C. We'll be starting momentarily here, live from New Haven at the Yale Law School. Right, if we can ask for everybody's silence, then we'll encourage some speech to follow. Washington, D.C. and New York, we're getting ready to go, so thank you for your indulgence. Washington, D.C. and New York will be starting momentarily, so we appreciate your consideration. Can you hear us in New York and in Washington, D.C.? Yes, okay. We'll be starting momentarily, so please, silence, please. As a First Amendment person, it's hard for me to speak those words. Welcome to this Salon. It is a pleasure to be here. I am Ronald Collins, and I am introducing today's program. It's a First Amendment Salon, which is being done in conjunction with the Floyd Abrams Institute for Free Expression here at the Yale Law School. The First Amendment Salon began as an outgrowth of a discussion that I had with Lee Levine, a noted media lawyer, and David Stover, a noted First Amendment scholar, both Yale law grads. And the idea was to establish these First Amendment salons in order to bring the academy and the practicing bar together for a variety of dialogues on various timely topics related to the First Amendment. The salons typically take place in New York City, Washington, D.C., or here at the Yale Law School, and they are made possible in addition to what the Floyd Abrams Institute helps us do, to the support of Levine, Sullivan, Koch, and Schultz firm. And what is being videocast today is at their offices in New York City and in Washington, D.C. In September of 2014, the Salon formed an association with the Abrams Institute here, and we're delighted to have that support. This past summer, the Salon went on the road, and we had our first dialogue debate between Erwin Chemerinsky and Eugene Volokh at the law firm of Davis Wright Tremaine in Los Angeles. This is the 7th such salon, and we are delighted to have it here today at this school. Before I close, I'd like to extend my sincere appreciation on behalf of all of us at the salon and here at the Institute to Sandra Barron, a respected media lawyer and resident fellow here at the law school, and to David Schultz, a media lawyer and clinical lecturer here at the law school. So Sandra and David, thank you very much for your help, which is much appreciated. We will proceed with the discussion of the case, and we have, in many respects, what we'll be hearing today is very much a Yale law story. The opinion that will be discussed was written by a Yale law grad. It was joined, that opinion, by another Yale law grad. There was a concurrent opinion by yet another Yale grad. And we have 3 Yaleys here to talk about that. A distinguished journalist and Supreme Court correspondent, Linda Greenhouse, your own Dean Robert Post, and of course Floyd Abrams. And with that, will you please join me in welcoming them?
Okay, thank you, Ron, and thank you all for coming. I know there are a lot of competing events today, so glad to see all of you. So as you know, our discussion is going to be a discussion, really not a debate, is inspired by a case that came down from the Supreme Court last June. It was kind of swamped by cases that people pay more attention to, a case called Reed against Town of Gilbert, which I will describe very briefly because our conversation is inspired by that opinion and ways of thinking about it, responding to it, but we're not going to limit ourselves to that opinion. Reed against Town of Gilbert was a 9-0 outcome although not a 9-0 opinion, majority opinion by Justice Clarence Thomas. And the case concerned the constitutionality of a sign ordinance in a town in Arizona. The ordinance regulated 3 kinds of signs in 3 different ways. There were ideological signs, that is to say, signs that conveyed a non-commercial message, and they were in the best position. They could be the biggest, they could be in the best places. There were political signs, those were more limited in their size and in their location. And then, at the precise issue in this case, there were what the town called temporary directional signs, such as church services today in such and such a place. These were quite limited, they had to be quite small, they could only remain up for a short period of time. So a pastor of a little church that didn't actually have a church building, but depended on people showing up at different places from following their signs, he brought a lawsuit in federal court saying that these distinctions violated the First Amendment, and the Supreme Court, all 9 justices agreed. Clarence Thomas's opinion holds that this was content discrimination per se, on its face, subject to strict scrutiny, end of analysis basically, end of opinion. Justice Thomas said, a speech regulation targeted at specific subject matter is content-based, even if it does not discriminate among viewpoints within that subject matter. Justice Breyer and Justice Kagan, Justice Ginsburg concurred only in the judgment. Justice Breyer said that this presumption of unconstitutionality, which of course is what strict scrutiny is, he said it goes too far because, quote, virtually all government activities involve speech, and regulatory programs almost always involve content discrimination. The government decides to regulate this and not regulate that, and so on. Breyer said that this was a recipe for judicial management of ordinary government regulatory activity. In other words, it's locked up, revisited. And in fact, Justice Alito, concurring fully in the Thomas opinion, felt moved to write a concurring opinion. Obviously, he was a little bit concerned here. And so he listed a whole bunch of signs that he thinks would be permitted under this holding. Very interesting concurring opinion, which he basically sketched out the legislation that he would find appropriate under this holding. So this raises very deep questions about the use of the First Amendment as a regulatory or deregulatory tool. What is content discrimination? And what is the line between content discrimination and viewpoint discrimination? And does a lack of viewpoint discrimination actually matter at all for the analysis? Does the context matter? So my former New York Times colleague, Adam wrote a provocative column about this case late in the summer, and that's what kind of led to this Salon, in which he called Reed against Town of Gilbert a sleeper case of the term. And he quoted both Dean Post and Floyd Abrams. He quoted Robert as saying that this opinion would roll back consumer protection back to the 19th century. And he quoted Floyd as being very cheerful about the important enhancement for the protection of speech that he thinks the opinion gave. So just to kind of situating our 2 discussants here, I look back at Dean Post's Tanner lectures of a couple years ago, which was published in 2014 as a book called Citizens Divided, in which he complained that that First Amendment doctrine has become, quote, a repository of abstract and categorical rules, unquote. Floyd Abrams has published several books recently. His 2013 book, Friend of the Court. I noticed in the introduction you say that the First Amendment is too important to be left to scholars. So maybe that's why you're here today. In your speech a weekend ago, Floyd, accepting the Yale Law School Association's Award of Merit, you took Justice Breyer on directly and Dean Post on obliquely. You said that the purpose of the First Amendment was not to facilitate self-government or anything so instrumental as that, but was simply to put speech, quote, beyond the reach of government, unquote. So I'm going to turn it over to you first for your thoughts about Reed against Town of Gilbert, what it implies, and where we are today with this very fascinating question.
Thank you, Linda, and thank you all for coming. The Beyond the Reach of Government that came from James Madison, but I thought I could use it too. I feel a little bit exposed. I look at Robert Bork staring down on the top left over there. I wonder how much of what any of us are going to say he would agree with. The Reed case is part of an ongoing debate on the court, a great moment, which deals, on the face of it at least, with what standard of review is to be applied to what sort of conduct. The vote of 6-3, really, as Linda correctly pointed out, in the case was the same vote with the same people as in the Supreme Court case in 2011, a case called Sorrell versus IMS Health, a very important case also, same alignment of 5.
This is Legal Shield returning your phone call. Our callback number is 1-800-375-3089.
I'm oversimplifying that, but on the First Amendment, or on the broader First Amendment side, and 3 of them are liberal members saying that this had all gone too far, either because in the earlier case it involved commercial speech, and in this case more generally, it was too, as Linda said, too Lochner-like. It involved the courts in what would be a constant weighing process of the sort that they'd engaged in when, all those years ago, the Supreme Court held unconstitutional New York law, basically holding, basically saying that bakers couldn't work more than 60 hours a week and otherwise couldn't be paid more than X amount. It seems to me that the Reed case should first be understood in the way it was written. Obviously, Justice Thomas, but not just Justice Thomas, obviously 6 members of the court thought it was important enough to take a case that they could have decided, as Justice Kagan's concurring opinion made clear, within almost any application of any legal standard. Justice Kagan said that this statute wouldn't pass the laugh test. 3 different categories, and depending what category in, it determined how many signs you could build, how big they were, and all dependent on what is on the sign, all of which makes plain that you can't justify the statute based on traffic safety, because the words are not the reason that you assert traffic safety. Only content was involved in the decision. And I think what we're coming to is a time in which the court more and more is likely to address issues involving what can be viewed correctly as economic regulation, but within the prism of deciding what impact the First Amendment may have on those regulations. Take an example which the court has never reached: stockholder contests. There are enormous elections of sorts within large public companies about who should run the company and what they should do about it. This has always been held to be a law of its own and governed by securities law. The Reed case allows an argument to be made now that all these are content distinctions, that various forms of regulation, the Federal Communications Act, involves content distinctions. And what Reed says is when we're talking about content on the face of a statute, it is immediately to be subjected to the strictest form of review, the form of review which starts with the notion that the statute is presumptively unconstitutional and puts a very heavy burden on those who would sustain it. Now, why did they do that? I mean, what are they thinking when they're doing that? Taking them at face value, as I think we should. Listen to 3 quotations from the Reed case in which Justice Thomas is explaining not what prior precedent is, but what the underlying theory is of applying strict scrutiny. At one point, he says that speech, quoting from another case that we're not here to discuss, but has the initials CU. Speech restrictions based on the identity of the speaker are often used as a means to control content. And he says that the important thing here is that, quote, the innocent motives do not eliminate the danger of censorship presented by a facially content-based statute, as future government officials may one day wield such statutes to suppress disfavored speech. And another quote. What is he saying? He's saying, as a prophylactic matter, we need sort of broad protections for speech by imposing the highest level of legal standard on those who would sustain restrictions on speech based upon content. And I think it's made clear in the previous Sorrell case that, at least it's very likely, that all 6 of these members of the court would say that's true with respect to commercial speech as well, at least for the most part. I'm of the view that they would not say it with respect to commercial speech that was false or misleading, but that as a generality, the fact that the speech is commercial in nature is of a sort, is not of a sort to strip it of its presumptive, as they view it, First Amendment protection. A final introductory thought. All this goes back to the first commercial speech case, the very first one involving commerce as such, involved a Virginia statute which barred pharmacists from putting the price of drugs in their window. And there were reasons for it. It could lead to price wars. It could lead to a diminution in the purity of the drugs being offered and the like. And Justice Blackmun, writing in that case, said this. He said that consumer interest in the free flow of commercial information may be keener by far than the consumer's interest in the day's most urgent political debate. And what he was saying is that the price of drugs to most people is more important than who they vote for, or at least what they think about political matters. So while Reed itself was not a case involving commercial speech, there are still disagreements about what is and what is not commercial speech. But at least pursuant to most doctrine, the Reed case involving how many billboards you can put up and the size of them would not be, I think, considered commercial speech. It intersects with this ongoing debate about 2 separate but interrelated matters. One is, what is the scope of review to be across the board, and shall it be across the board as the court looks at these statutes? And the other, not directly raised in Reed, but very much in Sorrell and raised in Justice Breyer's opinion in Reed, is, should it be any different when we're talking about commercial speech? Those issues are going to be in front of the Supreme Court for a long time, and a lot of you, I hope, will be involved in resolving them.
Thank you, Floyd. Let me turn this over to Dean Post and maybe ask him, in addition to what else you were planning to talk about, to address the provocative question that Floyd leaves us with, whether there's any functional distinction anymore between commercial speech and non-commercial speech, or are we all just in strict scrutiny land? And secondly, Floyd's reference to the Virginia pharmacy case, the grandfather of commercial speech cases, at least raises the thought in my mind about the extent to which we expect the court to look at context, as Justice Breyer says, when it's looking at a speech regulation. Because, of course, I think the court was very well aware in Virginia pharmacy that it was dealing with a protective law that was protecting the little pharmacies against the big chains, because the big chains could undercut them in price. So it was, yes, it was a pro-consumer regulation in that sense, in getting rid of an obstacle to consumer knowledge. But let me not go on with this, but I'll turn it over to Robert.
Thank you, Linda, and thank you, Floyd. So I want to, actually, the first commercial speech case is not Virginia pharmacy. It's a case called Valentine in the 1940s, when the court addressed the question of liberty of commercial speech. Said there is no such liberty. It's outside the coverage of the First Amendment altogether. It shifts its position in 1976. So we have to ask, why does it shift its position in 1976? What is it shifting to if we're going to deal with the question of commercial speech? But I don't think that's the place to begin with what Floyd said. So Floyd is talking about the regulation of speech being outside the control of government. And when you look at the First Amendment, which seems to have the form of a rule, Congress shall make no law regarding infringement of the freedom of speech, it seems to be rule-like in that way. The trouble is, in that rule, what is speech? Right? So here's a very, very simple example. I have a rent control statute. What is that actually regulating? It's regulating the words I can put in a contract. Every contract is speech. It's words on a paper that's meant to communicate. If I put a contract before somebody, anyone, and said, is this written document speech? They would know. The contract could be in a book form. It could be a book. They would call it speech. And yet none of us would conceptualize that as speech. So the conceptualization of something as speech or as not disguises a lot of work. If we're simply to say everything that communicates is speech, we're going to be in the position of saying, just for example, most antitrust law is unconstitutional under the First Amendment. We're going to be saying most product liability law, insofar as it concerns warnings by manufacturers, are unconstitutional. Or just take something very simple like professional malpractice, right? You go to your accountant gives you a statement of your assets and liabilities, and it's wrong. It's totally inept. You sue, and the law punishes the accountant for that under malpractice tort law. Does the accountant have a First Amendment defense saying, as Holmes says in 1919, November, oh, well, what I gave you was an experiment. As all life is an experiment, I'm protected under the First Amendment. Is that a constitutional question? Floyd's invocation of the First Amendment as a simple rule tied to speech would say yes, but let me say no sane society would make that speech. So we need to do a lot of work in saying what is speech and for what reasons do we protect it. Even though the First Amendment comes across as a rule, we have that rule for certain reasons. And then the question is the application of that rule consistent or inconsistent with those reasons? That's the issue which is always on the table. So if we come back to commercial speech, Floyd himself said, of course I wouldn't apply it to misleading commercial speech. Well, you cannot prosecute the New York Times for being misleading. That would be content discrimination. We all know the case of Alvarez. You can be deliberately false, and you're protected for a certain kind of speech, but not if I'm selling you a product. This is Dr. Oz, on the television. If he's selling you something, the FTC gets to look at what he's selling you and whether it's misleading, but not if he's stating his opinion as a citizen. Why do we account for that difference? There is going to be a doctrinal difference. It's not going to be explicated by the fact that we have the First Amendment as a rule. It's not going to be explicated by the notion of content discrimination. It's going to be explained, if it is explicable. I mean, we have a choice. We can read Sorrell as overturning the FTC and all regulation of commercial speech. If we want to go down that route, that's pretty extreme. But if we don't want to go down that route, then we need a different account of why we're allowing this regulation of commercial speech, regulations that we would never for a second allow on political speech. Why is that? How do we account for that? The court has, I'll give an account in a minute. I just want to go back to this notion of content discrimination in read, because we started there. The court has had this notion of content discrimination since the 1970s. It was actually working off an article by Jeffrey Stone, which gets picked up in a case called Mosley, and the court kind of imports it because of the intersection of First Amendment law and equal protection law. Discrimination sounds a lot like what the court had been doing in the equal protection area. So it began to intertwine this idea of discrimination, of content discrimination, viewpoint discrimination, with First Amendment law. And the idea was, as Floyd correctly quoted Clarence Thomas as saying, well, we don't want to have content control. But, you know, of course, when we do malpractice law, that's exactly what we're doing. We're doing content control. If we were to have a law, for example, that use tort law to police product instructions. So suppose you buy a car and the instruction manual says to attach these two wires, and you do it and it blows up, and you sue the manufacturer, and you win. A tort liability, First Amendment defense? No, why not? Because we want to have content control. Even though it's speech, it's a product manual. It's given to you, you're reading it, you get the idea. It passes what those of you know who know First Amendment law know is the Spence test. So we want content control in certain instances, and we don't in others. So there is a notion of content discrimination that is doing more work than a simple flat rule can tell you. It's always implicitly applied to certain circumstances and not to others. And that has put enormous stress on the court's historical use of the concept of content discrimination. In point of fact, there are at least two branches to the court's doctrinal use of the idea of content discrimination. The first derives roughly from equal protection law. In some decisions, the court was saying the notion of content discrimination derives from the purpose of the regulation. Even though on its face it may discriminate, if its purpose is other than the suppression of a particular kind of speech, then it's not content discrimination. These are cases like Ward, in which you talk about value control, and Kennedy says the justification or purpose of this regulation isn't the suppression of speech, hence not content discrimination. Or most famous, well, I won't go. And a second notion is the notion of facial discrimination. If the statute on its face makes a distinction, then that's content. This is like a facial classification in equal protection. That's the analogy. Strict scrutiny, if you have a racial classification, of course, that's obscure in equal protection, just like a facial classification here. But in Reed, Thomas makes it very clear. If the words point to a difference in the content, well, lots and lots of things do that. The court has done that before, Reed in only one case, a case called Cincinnati. If you actually take that seriously, all the examples I gave you are now First Amendment strict scrutiny. Every malpractice law, every, under Central Hudson, every regulation of misleading commercial speech, SEC, contract law, label law, just lots and lots of areas of law that occur in regular speech are now subject to strict scrutiny. The third, equal protection, is many justices have argued that the effects of a regulation, if they are disparate on content, should be viewed as content discrimination. The court has time and again, most recently in its regulation of the Massachusetts bubble statute for abortion protesters, has said that does not constitute content discrimination. So that's one branch of content discrimination. A second branch derives from First Amendment doctrine itself, and this is the distinction between whether the statute is regulating the primary or secondary effects. Primary or secondary effects. So if it's a direct effect, like the audience reaction to the speech itself, that's content discrimination. So an example of that would be if I charge more for security for a speech that's in which people are going to get angry, the court has said that's content discriminatory because that is regulating how people can respond to a speech, and that's what we want. That's what really we are trying to protect, is the ability of a speaker to cause certain reactions in an audience. But sometimes the court has said, most famously by Justice Rehnquist in Renton, but it really goes back to many cases, if the statute is regulating the secondary effects of its secondary effects. So, for example, there are zoning statutes that say if you have an adult picture, so it depends on the content, it plainly would be content discrimination under Reed. It has to be zoned in a certain area, and that was challenged as content discriminatory. Brennan, actually, in the concurring opinion in Retton, adopts the position that Thomas takes in Reed, but the majority of the court goes off and says, no, the secondary effects here, meaning it's regulating property values, and you don't want to have adult theaters intrude in the residential areas, blah, 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 like that. So, and the court has many times drawn on this distinction. So the court has been all over the map in its distinctions of content discrimination, and one reason is that it's applying it to so many different circumstances and to so many different kinds of speech, and content discrimination is not a helpful distinction when you do that. That's part of the pressure on the concept of consent, because you have to worry about why you're asking that question and what you mean by that question. In the area of malpractice, in the area of the regulation of commerce, you care about content control. Whereas in the area of political speech, you want to have hands off. And unless you make that distinction, then everything we do being human is through speech. So that's part of the problem with a flat ruling, like you see in Reed. And in Sorrell, Justice Kennedy does seem to go there, although he backs off in the end of that case. This is the case about forbidding pharmacies from selling data about your doctor's prescriptions to pharmaceutical companies. That's what the Sorrell statute was. So no one was talking to begin with. It was the transfer of data. The court conceptualized the transfer of data as speech, and it said this is content discrimination, therefore it's alarming, but then it goes off on Central Hudson. Central Hudson, of course, rests on the very notion of content discrimination and this distinction between misleading and non-misleading speech. Now, why does Central Hudson, to end on commercial speech, why do we allow the regulation of misleading consumer speech and not misleading political speech? What accounts for that distinction? So this is where we come back to Valentine and to Virginia Farms. So Valentine was coming out of the Lochner days and the rejection of Lochner by the New Deal Court. It did not want to get into the constitutionalization of commercial exchanges. It did not want to revive Lochner. By 1976, the court had sufficient distance on Lochner. It had already decided Griswold. It was okay with the regulation of commercial transactions, so long as it didn't revive Lochner per se. And the court was roundly critiqued for implicitly reviving Lochner, but the court had a defense to that, which was reiterated by Powell, who was very strongly connected to this revival of protections for commercial speech. Powell said, we protect commercial speech because of the informational function of commercial speech, because it provides information. That means that we protect commercial speech because of the rights of a listener, not of the rights of a speaker. That's an extremely important difference. For one thing, it means that you don't imagine the commercial actor as an autonomous actor. Lochner most fundamentally imagines the person who is involved in commercial transactions as an autonomous actor, freedom of contract, and it protects that subjective freedom to contract. The court did not want to be in the business, starting in the 1970s, of reviving that notion of commercial actors, because that does lead to basically the constitutionalization of all commercial regulations, which happen through speech and through contracts, etc. The court therefore said, in the area of commercial speech, we're going to regulate from the vantage point of the listener and what information is transmitted to the listener. Now, a lot of things follow from that distinction. We protect political speech from the point of view of the speaker, so we protect the subjective expectations of the speaker. We don't allow the state to compel the speech of a political speaker, and we don't allow the state to second-guess the truth and misleading character of the political speaker, and most fundamentally, all political speakers are equal as democratic citizens. That's what the rule against content discrimination embodies. It's that notion of political equality, that we all should have an equal chance to influence public opinion. Commercial speech, by contrast, informs a listener, therefore the court can make sure, as it said many times, the stream of commercial information flows cleanly as well as fully. So if you're giving information to a listener and it's bad information, the state has an interest in checking it, because its information is the value to the listener only if it's not misleading. And the second point is we can compel commercial speakers to speak, which we do routinely. If any of you have leased a house, there are compelled disclosures of a leaseholder, right? You have to disclose this, and this. We won't let you, we can't compel you as a political speaker. It's outside of campaign finance, which is a distinct provision, to compel certain things because we don't want to interfere with your subjective relationship to your speech, whereas in the commercial area, compelled speech increases the constitutional value of the transmission of information. That's the value. So I'll stop there.
So, Robert is framed to boil everything he said down, but does your First Amendment, Floyd, take account of purpose, the purpose of the regulation?
I don't understand the question. You're asking me if the Reed case?
No, the first,
My First Amendment?
your ideal First Amendment.
Sure, there are lots of times where the purpose of purpose of legislation would bear upon whether it's constitutional, and indeed the court said that in Reed too. That once you get past the first look, Reed's concept is first you have a look to see if a statute on its face is content based and certain other matters. And then even if it's not, then you go on and have further look, including the purpose of a statute and the purpose, if necessary, of the people who drafted the statute. So it can be relevant. I mean, I have to say that Robert has correctly demonstrated that this is a subject with a level of complexity to it. There are a lot of cases in this area which we will test you on later, and they do indeed go in different directions for a variety of social reasons, legal reasons, and the like. They are all over the map, that's true. We want it, Robert said, in some cases, but not others. We want to protect speech. The question is, what are the basic rules to be as we look at this? And it's perfectly true that because we have legal doctrine aiming in a variety of different ways, like searchlights over a plane, that the searchlights overlap sometimes and conflict with each other. One starts with the principle of the broadest First Amendment principle that I was trying to articulate last Saturday here, that the purpose of the Bill of Rights and the First Amendment is to limit the government, period. That's why we have it. We wouldn't have it but for that thought, and that is its core purpose. That doesn't mean that the First Amendment doesn't offer value in terms of self-government, education, a variety of other elements, but the broadest First Amendment articulation is that. And then we get to the point where, yes, sometimes we're looking at the purpose of legislation, and sometimes we're not. And sometimes, sound trucks late at night, we have time, place, and manner restrictions. Yes, it's very complex. The question is, what are the broad principles that are going to guide us, if there are to be broad guiding principles? I don't for a moment think that the Reed case, even if followed to whatever we think its end is going to wind up with total or even major clarity. It can't. The whole topic is suffused with difficult areas. So when I say earlier that I think that we will continue to have, even as we move commercial speech protection closer to political speech, that we still won't be protecting false speech, and we still won't be protecting misleading speech, even though we do protect just that sort of speech in the political area. These are the sort of things that are going to be worked out through the years with all these cases as background. And there's no way that there's going to be total clarity and consistency and doctrinal purity in doing so. But what the recent cases are starting to do is two things. One is to say that commercial speech has more value than Robert affords it. It matters more to more people. And while political speech may, and I think is, more important, that we are likely to, and I think wisely, likely to be affording an increasing amount of protection to truthful and non-misleading commercial speech, if for no other reason that it has such an important impact on our economy, on the public. It's that important. At the same time, I think we're also likely, and here I think Justice Breyer makes a very valuable point, we are likely to be subjecting statutes which are on their face content-based to strict scrutiny. And Justice Breyer says, in effect, what are you going to mean by strict scrutiny? Or is that going to be the same sort of really tough, almost unavoidably impossible to overcome barriers anymore? Or are we going to say, yes, the FDA has certain roles to play, some of them are content-based decisions, and yeah, you know what? That's going to pass strict scrutiny. We'll find a way, as we do, find ways to do those things. And Justice Breyer is right, I think, in warning that one of the impacts of saying, even as a generality, that we're going to have strict scrutiny about statutes that are content-based on their faith, one of the problems is that we're going to start calling something strict scrutiny, which is no longer so strict. And I think that's a real, genuine danger of this sort of approach. It doesn't seem to me any more dangerous than a lot of other things we do in the law, but it's a real cost of imposing strict scrutiny more often, as we are now likely to do.
So I think I totally agree with Floyd that the cases are trending in the way that you say they're trending. And my interest in this as a mere academic is to say, okay, so what principles can we think about that gives coherence to the way that the court is moving in a way that we're all willing to live with and that will avoid, I think, consequences that both of us would agree are really terrible, like we don't really know what strict scrutiny is anymore, so the kind of speech we really want to protect, which is the regulation of political speech, is now permitted because we have destroyed the tool, the doctrinal tool of strict scrutiny, which allows us to protect the speech which is most important to us. So I wanted to say, in response to what you just said, I don't think it's a sufficient description of the purpose of the First Amendment to limit the government. I think you have to say to limit the government to what end, because otherwise we have no account of what speech is. And unless we have an account of what speech is, we have zero idea of how to apply the First Amendment in the range of cases that go from contract to malpractice to product liability to political speech, first. Second, we have no ability, unless we say limit the government to what end, to support the proposition that you just put on the table, and I agree with it, that political speech is more important, to use the word you just used. How do we know it's more important? We don't know it if the purpose is only to limit the government. We have to know it because it's to limit the government in some way connected to the constitutional values of government. Otherwise, all speech is equal if we just stop to limit the government, full stop. And we need an account of why commercial speech is different than political speech if we're going to retain this distinction, this fundamental distinction about content discrimination for misleading and false commercial speech. At the very same moment, we reject it for political speech, which we see the courts doing now. I think the Eighth Circuit just said you cannot regulate political speech even if it's deliberately false with actual malice. There can't be and we need an account of that.
So we have about 8 minutes left, I think, and we have 3 different audiences, some of whom might have questions. Obviously, we're not going to resolve anything here, and I hope we can convene again. Akil.
So this was spectacular. Can they hear me over there?
I'm coming to use this mic.
We have a question from our New Haven audience.
So I just thought this was spectacular, so thank you for this. A very high level. On Citizens United, I think I'm actually with Floyd, because political advertising has an effect only if voters on election day find it persuasive, and that's one person, one vote, secret ballot. But on this one, I think I'm with Robert, and I just wanted to articulate a slight middle, a third position. So it's not just that we can't ever have a world in which commercial speech and political speech are identical, but that distinction, which the court has always followed, is itself content-based. So it can't be the case that we have this strong objection to content distinctions as such, and it proves, I think, way too much, as Robert suggested. I do think we get off on the wrong foot if we focus just on speech, and I'm with Robert also in saying that we need an account of why government is limited. I wouldn't start with speech, the word. I would start with the freedom of speech, which is what can't be abridged. And at its core, it was freedom of speech and debate in the parliament. It was about democracy and self-government and how we govern ourselves. And we could broaden it out to a as my colleague Jack Balkin is doing in recent work, to more broadly a democratic culture and not merely just elections. But when we do that, I do wonder about, so two things. One, here's one of the reasons. I don't think it's just because there's an individual autonomy interest in political speakers. Because if that were the basis for the distinction, Robert, then when we have institutions in the political domain, they should be limited just as commercial institutions are. When we have individual actors trying to sell you something commercially, we couldn't. So I don't think it's quite that. I think we regulate the SEC differently from the FEC, Securities and Exchange Commission, for arguably misleading commercial speech, different than the FEC for arguably misleading political speech, in part because we trust the government less when it comes to the regulation of political discourse than commercial. And so that needs to be brought into the analysis as well. So mixed claims of fact and opinion and all the rest are treated differently based on whether we trust the regulator, not just whether there's an individual interest or a commercial or an institutional one. Second, and this is, and I'll shut up, I will shut up. On commercial speech, I don't, Robert, I'm to your left on this. I don't think that it is just about that we should treat as a strong constitutional interest the free market interest in a consumer to get truthful and reliable information. That's way too Lochner-like to me. That is collapsing free speech with free markets. I don't think quite that in and of itself, because if we can prohibit certain things altogether, even if there's an individual free market interest, if we could prohibit tobacco altogether or gambling, I'm not sure why we shouldn't be able to discourage tobacco and gambling for reasons having nothing to do with suppression of democratic culture, just because we think it's just bad for consumers to do this, whatever they might think. So I'm not sure, Rob. I think you're buying into too much when you invoke Justice Powell on the free market informational values, informational interest of the consumer.
I think there is a difference between political speech and commercial speech, and at its core it's this. Political speech, the freedom of political speech, protects our rights as citizens against the government. It has historically been viewed as the core of the First Amendment, I think rightly viewed as the core of the First Amendment. That's what keeps us free. Commercial speech doesn't keep us free. It keeps us informed. It keeps us better informed by allowing more people to say more things about commercial matters And obviously, we can, some other hour, we'll talk about what commercial speech is and how it should probably be defined. But to take one example, it's very important that, in my view, that commercial speakers who speak for reasons of commerce, who speak because they want to sell something, be able to participate in the public debate about the legitimacy of their products. Tobacco companies, to take the last example, pharmaceutical companies, I think, have to be permitted to play their role in the public forum about every aspect, including the safety of their products and the role of their products in American society. That said, again, I agree with the notion that speech which protects our freedom is different in nature than speech which does give us more information. Being allowed in that first case in which the First Amendment was held to protect commercial speech, being allowed the price in the window of drugs, and there are later cases of liquor, where the argument made by the state, a losing argument, has been where we're going to have price wars about liquor. People are going to buy more. It's bad for them to have liquor. Liquor is legal, but it's a bad good. It's a dangerous good. Therefore, let's discourage people from buying it by not allowing the full advertising of it. That, to me, and to the Supreme Court for some time now, is an unacceptable reason. Even though, if we barred all advertising altogether, we could still go about our business as free people. We would be less informed about important aspects of the real life that our citizens live in a way that's unacceptable.
I'm informed that actually we don't have to stop at 1 o'clock. We can keep going till 1:30. So I'm going to invite questions from our New York and DC audiences, but first, Robert has
3 quick points in response to Akil. First is, I would not say it's an individual autonomy interest. To me, it's an interest in self-governance. The question is, who is the self that is governing? Answer, it's all of us. How do all of us make a self? Through participating communicatively in public opinion. Right. That's why we don't trust the government, because we don't want the government, we want to make the government responsive to us rather than the reverse. So that accounts for that. So the trust depends on the function of the speech. First. Second, I agree with you also that commercial speech cannot depend upon the interests of consumers in receiving price information merely as consumers. So in Virginia Pharmacy, Blackman offers 2 rationales for why commercial speech is protected. The first is the efficiency of the market by reducing information costs, which is analogous to our individual interests in knowing what the price of toothpaste is. I think that's a bad idea because it says that the First Amendment makes an efficient market in communication a constitutional value. That cannot be right. So instead, I have seized on the second rationale, which is it informs us in our capacity as citizens to know what our commercial life is like. So we can't know whether we want to have price controls on drugs or Obamacare unless we know the price of drugs. And I've labeled that democratic competence in other writings, and I think that is a consistent rationale. And finally, your point about being able to ban it altogether, all of these commercial speech cases have rejected the rights privilege distinction. They all have said it is not the case that because you can ban the activity, you can therefore ban the speech about the activity. So they have rejected that rationale. Well, many, yeah.
And before the commercial, yeah.
questions from our remote audience.
If Linda Fricker, Colorado, New York, I think it's fair to say that Reed v. Town of Gilbert is a billboard sign case, among other things, and as Floyd knows, I litigated, yeah, and the infinity billboard cases invariably produce bad and messy law. But there's one, well, in all the billboard cases and all the opinions of the Supreme Court that has never been questioned, and that is the distinction between on-site advertising signs, there's a sign that says, there's a diner keeper, and then off-site advertising signs, advertising beer, what, and the former are entitled, have been consistently entitled to protection, while the latter are subject to a greater regulation. Did the indoor judgment, Floyd and Professor Post, did the House majority really intend overturn that whole series of holdings because that's obviously a content-based distinction? Did they intend to overturn, for example, Lehman, the city of Shaker Heights, which permitted a community to exclude all political signs from its buses? How far do you think they really intended to go?
So I would say they didn't give it much thought. So on the distinction between on-site and off-site, which, as you say, is plainly content-based decision, there are two district court decisions going opposite directions after Reed. Northern District of California says, using Renton, this is not justified, it's not the purpose to make content. And Western District of Tennessee, I think, says this is content-based because it obviously is. Strict scrutiny, it fails. Alito, in his concurring opinion, says specifically on-site versus off-site is okay, but given the way the opinion goes out of its way to put on the table a methodology which would strike it down, it's hard to know what that means.
I think I agree that the court is unlikely to have considered all the non-sign implications of what it did. But in terms of signs, I think they certainly put at issue. I think they certainly meant to put at issue prior opinions which distinguish based on content of signs for one reason or with one message rather than another message. And I'd be surprised, very surprised, if the Lehman case and some other cases didn't fall.
I'll just mention that Reed was argued in early January and not decided until June. I think King against Burwell was argued later than that. So obviously something was going on inside the court to create a majority opinion. I think the Alito concurrence maybe didn't start that way.
You could also, I really turn to you on this, Linda, but my reaction on reading it is that the other members, or the majority of the members of the majority who joined Justice Alito's opinion had asked Justice Thomas to include that in his opinion, and he declined to do so.
Yeah, there was something was going on. More questions either here in New Haven or remotely? So I'll ask one. I'd like to get back to this possible watering down of strict scrutiny and whether the next front is really going to be on defining a government compelling interest or on accepting a claim of narrow tailoring, and what are the implications of that?
The cases that have been coming up so far are begging cases, statutes which make it a crime to beg in certain areas or at certain times. The Seventh Circuit reversed itself as a result of the Reed case, having held that a general anti-begging statute on the streets or just about anywhere was constitutional, reversed themselves specifically on the basis of Reed, saying that they could not find that it met strict scrutiny. And in a recent Colorado District Court case, the court taking a very hard look at a very specific statute, which said things like no begging in bus stations, no begging in places of amusement, no begging between 6 p.m. and 10 p.m. Said, we don't have any proof. We have no evidence here that anybody who's begging on the street between 6 and 10, there's not a word in the legislative history about bus stations. This falls, that falls, that falls. And that's all because of the Reed case.
Not too long ago, that just would have been a time, place, and manner holding, right? Seriously.
Well, yes and no, because it talks about a specific kind of speech based on its content, which is asking for money. And the panhandling statutes are now falling, like dominoes. But the interesting theoretical question here is that conservatives on the court used to speak for the cohesion of community. They would regulate obscenity. They would regulate in ways in which communities, they would allow regulations in the name of community cohesion. This methodology, which Reed goes out of its way to stress, this, flat, if the statute makes a distinction as content, it's basically out, or we've lost strict scrutiny, one or the other, would not allow communities to protect themselves, their quality of life, etc., through statutes. And it's exactly the opposite of traditional conservative values. And these traditional conservative values are the thing that's motivating right-wing mobilization in the United States today. You see it in the anti-immigration movement, which is the same thing as a community cohesion, and how that right-wing mobilization is going to sit with this rule-bound, acontextual First Amendment on the right is, to me, a crucial question in the next 2 decades.
But of course, you could say just the same as the left. The language from the Citizens United opinion, which the court quoted from and adopted again, is language which liberal jurists would have easily signed on to years ago. Speech restrictions based upon the identity of the speaker are all too often a means to control content. This sort of sweepingly broad, and it is that, articulation of future danger, not this case, future danger as a basis for a very broad ruling is the stuff of the Warren Court.
I disagree. I think that what's made this not the stuff of the Warren Court is everyone understood an implicit frame for that generality to mean in the context of the public forum, in the context of public opinion. No one thought in the Warren Court that putting a different responsibility on lawyers for their speech when they speak to clients or to a court was a problem. And that's an identity-based, no, I would never have signed on to that general statement, understood as a general statement. And nor, I think, would any liberal in the 60s, because they wouldn't have conceived speech as applying to those contexts. It's the different frame in which this court is applying these First Amendment rules, which make them totally different in their veins.
But it makes them include all the areas that the liberal courts of the past would have wanted to include and more, right?
No, I don't think the liberal court would have said we have to toss out malpractice law.
I didn't say that. I said that language such as this very broad language, if applied to the sort of speech that you think, or call it the Warren Court, thought should be protected, is the ordinary rhetoric
Yes.
of its day.
Yes.
And what I'm saying is that rhetoric is, I agree with you, now being applied to many more, at least potentially, to many more and different areas, and that's what makes this so, put aside right or wrong or debating points, that's what makes this potentially so significant a move in terms of constitutional interpretation.
That's exactly right, I think.
Floyd, let me ask you the question that conservative justices like to ask Solicitor General Don Verrilli when he gets up to defend a federal statute. What's your limiting principle? So Robert has talked about, antitrust laws are going to fall, and securities regulation is going to fall, and so on. So where's your boundary?
I think the boundary, let me take one of the examples, antitrust law. I think taken as a whole, the antitrust laws, or say Section 1 of Sherman, would pass strict scrutiny. I think that's what they would say. And I think, I'm confident that's what they will say when it comes up, as will all sorts of regulations that we're talking about here. Now, again, I acknowledge that there's danger in saying this is strict scrutiny, that's strict scrutiny, that is a danger of this approach. But I think the world will not be quite as different as it might otherwise be by applying a very tough standard of a sort that we haven't before.
So I want to say two things about that. One is, if the world isn't very different, then of course it's going to tie itself into a doctrinal pretzel over the application of strict scrutiny. Second, look, for example, at this recent opinion by Jed Rakoff, a terrific judge in the Southern District, in which he finds that a New York law that prohibits a credit card surcharge is invalid under the First Amendment, because it's turning on the meaning of whether you give a cash discount or a credit card surcharge. That, he said, turns on the First Amendment, and therefore it doesn't survive strict scrutiny. Southern District strikes it down under the First Amendment, gets reversed by the Second Circuit, an opinion by Livingston, who says, what are you talking about? Price is not communication, it's not speech, it's an action. So that's different than applying strict scrutiny. That's chipping around the boundaries of speech. There's a lot of tools that are being used here. But of course, then you have to look at the Second Circuit and say, what do you mean price isn't communication? That's the premise of Virginia Pharmacy, is that price is communication. So what is going on here? And if it is, then what are we talking about in terms of the First Amendment?
Well, yeah, I mean, we do have cases, indeed, in which Judge Livingston has dissented in Sorrell, for example. Corona. She dissented in Corona and Sorrell. The Second Circuit opinion in Sorrell, which was affirmed, as it were, by the court in reversing the First Circuit opinion there. So we're going to have a lot of business,
So I'll wrap, unless there are questions, I will call this fascinating. Yep.
Hi, my name is Matthew. I'm an associate at Leading Sullivan. I just have a question. I don't want to get too far afield, but assuming that Central Hudson survives, what about, I guess the alternative to the question I was just asked, what's the limiting principle when it comes to what we actually do classify as commercial speech or not? And just to give an example, in light of the Supreme Court's recent ruling, many corporations came out and changed their logos to the gay rights flag. I think there is a convergence of political and commercial speech, and how do we draw a line between one or the other if we're going to recognize that difference?
I think if we define commercial speech as it has more generally been defined, effort to purchase and sell, which is a very narrow definition, leaving everything else as political or non-commercial, we pretty well know where we are. If we get into, as the 19th Court in California did, the motivation of the speaker, the motivation of the corporate speaker will always, on some level, and often only be for helping corporate profits. If that's sufficient, then we have an entirely different world, and we still have a great divergence in the definition of commercial speech that is being applied. And bear in mind, the Reed case is a very good example. It's not commercial speech. No one said it was commercial speech. It's trivial speech, a lot of it. But a lot of it isn't. And sometimes it's, speech which could border, certainly it would include in that third category, not political, not ideological, commercial. And they are treating, in that sense, commercial speech differently and less well than the other forms of speech that are better protected. That's one of the things that fell with the opinion in Reed, not because it was commercial, but simply because whatever it was being treated differently.
Yeah, I think Floyd is right. It's very, very hard. If you look at the cases, you can come up with 70 different definitions of commercial speech if you're being precise about it. And if you look at the academic law reviews, you can come up with 150 different definitions. It's very, very hard to know what commercial speech is. My approach, what I would say is, you actually define the category of speech by the constitutional value at stake. So if the constitutional value is self-governance, then we call it political speech, and we protect it in certain ways. If the constitutional value is the transmission of information relevant for self-governance, then we protect it in different ways. But that means that the definition turns on normative judgment about the relationship of a particular speech act to a particular constitutional value. And that's very controversial, but it seems to me the only way to solve the problem.
It puts a great burden on our fragile judiciary.
I would say that's what the courts do all the time, every day, in innumerable contexts that I could put on the table.
But, all I meant was that in the chaos that seems to be unfolding in the immediate aftermath of the Reed decision, I think shows us judges in a kind of a moral panic.
I think it is a real burden, too. And the more the courts have to apply overlapping, competing sometimes, doctrine makes it all the harder.
I'm going to wrap this up with the hope that we do another one of these soon because there's so much to talk about, and thank you all for your attention.